Further hearing in the appeal Halliburton Company against Chubb Bermuda Insurance Limited.
Yes, Mr. Crane. My Lord, your Lordship was asking me last night about independence, and I replied that the criterion was whether or not a financial dependency of some sort or some other form of dependency was established. And I referred to the case of Coakley and Bingham, which is not in the authorities, but I think was referred to below. And that was a case where over a period of 3 years, the arbitrator generated just under 25% of his entire professional income from a single source. So that's the sort of territory we're in, and it's not suggested that that's an element in this case. Lord, returning to the subject that I was addressing yesterday, namely the expectations of parties, having regard to the different type of reference under consideration, can I turn to a challenge decision of the LCIA, the relevance of which is that the decision recognises the particular characteristics of the London insurance and reinsurance market. The court will find it at tab 8 of the authorities bundle, A8, tab 210, volume 8, tab 210, page 2496, electronic number 3370. That was a case.
Sorry, which tab, please? Mr.
It's tab 210, Lord,
Thank you.
Last tab in volume 8.
Thank you.
That was a case involving a practicing barrister as arbitrator under the summary. And you'll see that the problem was that the barrister in question was currently retained as counsel by one of the parties. And in addition, had been asked, this appears from a full report of the authority, unfortunately this is truncated, had been asked to give an undertaking that he would not act as counsel for either of the parties while the arbitration was pending, and declined to give that assurance. So this is a pretty clear case in my submission. But for present purposes, the paragraph beginning at 411 down to 414 is instructive, where the LCIA division, considering the challenge, said that the nature of the London insurance and reinsurance markets was certainly to be taken into account when assessing challenges in arbitrations involving these markets. However, after weighing and balancing all the relevant facts and circumstances of the challenge, the division considered that in this individual case, the nature of these markets did not change its provisional conclusion. The division noted that London insurance and reinsurance markets were global markets which created numerous disputes, very often governed by English law and or subject to jurisdiction or arbitration in London, and with a limited number of solicitors and specialised barristers serving the industry. An overly strict assessment of an arbitrator's independence and impartiality under which any potential conflict was to be disclosed and led to removal without any test as triviality or a rule of reason approach might frustrate London's position as a venue for arbitration of insurance and reinsurance disputes, as it might be difficult or might take a long time to find a knowledgeable and experienced non-conflicted arbitrator. And then any such restrictive approach was also not required under the fair-minded and informed observer standard. The observer would acknowledge the characteristics of the London insurance and reinsurance markets and of the specialised legal professions serving those markets. He would also acknowledge that an insurance specialist might depend upon a limited number of law firms retaining his services, and that such retainers by a single law firm may generate a not insignificant part of his annual income. But as I say, there were pretty clear circumstances, other circumstances in that case, which combined to make the challenge successful, those to which I've referred. So that's the LCIA, recognising the specialist nature of this particular field. Can I now turn to the Arias report, which is appended to GAFTA's submission. Your Lordships and Ladyships will find that in volume 2 of the interveners. At tab 10, page 683 or 684 if you're working from electronic files. I should mention that the current chair of the Arias Committee is Mr. Scory, who sits behind me, and you'll see from this report that he and one other member who had connections with this case were excluded from the relevant inquiry. At paragraph 4, you'll see that the most widely purchased form of reinsurance or retrocession treaty is known as excess of loss. The purpose is to protect reinsurers against excessive loss arising from a catastrophic incident, such as a weather event or a man-made disaster such as Deepwater Horizon itself. When such an event proves costly, several classes of insurance and many insurers will be affected. And then the rest of the paragraph goes on to explain how an event of that sort produces a multiplicity of claims. With that background, can we turn to page 686, 687 electronic numbers, at paragraph 17. As indicated, this is a market served by a limited number of specialist law firms, assisted by a number of counsel who develop a distinct facility for reinsurance issues. Conventionally, it is the solicitors who manage the appointment process. It is they who would be seen to raise, in the first instance, any assertion about bias or apparent bias or about lack of independence of an arbitrator. And then in the next paragraph, by reason of the features set out in the next section, treaty reinsurance arbitration in London is a field of commercial dispute resolution where there is an evident probability that the same issue will be considered a number of times, sometimes on one programme of treaties, and sometimes on wholly unrelated reinsurance treaties, often in standard or fairly standard forms, by what is in practice a limited pool of specialist arbitrators. Against that background, the committee's appreciation of current practice is as follows. In the collective experience of the committee, it's not historically been the practice of arbitrators in this field to disclose that they have considered or been party to a ruling on an issue raised by an offered appointment, nor for them to disclose if they have been asked after accepting such an appointment to accept a further appointment considering such an issue in a second reference. Nor is it the committee's experience that arbitrators disclose how many prior appointments they have received from either of the parties, but the committee is not in a position to say that this element of practice is universal. And then, very properly, they refer to two recent disclosures by former judges, which are to the contrary. And then at paragraph 22, no member of the committee has become aware of any instance where either the frequency of an appointee's appointment by a party or his or her having ruled previously on a common or overlapping issue has led to an application to disqualify him or her from the tribunal. In particular, where the same issue affecting a reinsurance buyer gives rise to multiple references, usually one per layer of its programme, it's common practice for the reinsurance buyer to appoint the same arbitrator to each of those references, whether there are common reinsurers on those layers or not. The committee is not aware of that ever having been considered objectionable. And then 27, it's the committee's assessment, based on its knowledge of this industry and of the practitioners engaged in it, that no experienced practitioner appointing one of those individuals or being advised that one of them had been appointed by a counterparty would assume that this was to be the appointee's first arbitral acquaintance with the issue, unless the issue at hand was specific to the parties, for example, a question about the adequacy to an individual buyer's presentation of the risk. Then the last sentence in that paragraph, we consider a prudent and experienced practitioner would so assume because of this market's unavoidable tendency to generate multiple disputes about the same subject matter. The tendency arises as follows, and then they describe it. And then paragraph 36, the court will see the conclusion. In summary, the committee believes that practitioners in the field are well aware of the possibility of overlapping appointments and of the situations in which they are likely to occur. As the examples in the two preceding paragraphs show, one of which is at 911, in some instances a practitioner has been put on notice of the fact of an adverse prior decision to which that arbitrator was party and raised no objection. It's beyond the scope of this report to explore why this market adopts that approach to prior arbitral decisions. There may be several reasons, not least the current state of the law. Whatever the reason, the committee believes it relevant to make clear that to the extent set out above, practitioners in this market have not historically concerned themselves with the suggested unfairness referred to in the Court of Appeal. In this respect, GAFTA is not an exception. And my last reference in this field is to a decision of the Second Circuit in the United States. Again, I hope I can take this at speed. In which the Court of Appeal for the Second Circuit again made reference to the specialist nature of the insurance market and of the relationships that produced. And that's a case called Certain Underwriters of Lloyd's. It's in volume 4 of the authorities file, tab 93 at 1194, 2068 if you're working from electronic numbers. My ladies, this was a motion to vacate an award. And the test for vacating an award under the Federal Arbitration Act is to demonstrate evident partiality. It's quite a high hurdle, and I'm not referring to it for that. The passage in question is at 1194, 2068 electronic page numbers. And the motion was brought for non-disclosure by a party-appointed arbitrator of a series of relationships with one of the parties. And the question was whether that gave rise to evident partiality, and the answer was no. But in the course of the court's analysis, they discussed the nature of the insurance market and the relationships or connections that that would inevitably produce. And your lordships will see, the ladyships will see that at HN9, halfway down the left-hand column of 2068. And I wonder if I could leave the court to read that to themselves. It's probably more convenient.
Yes, thank you.
Thank you. Now, just turning to the Bermuda form, and forgive me if this is material that the court already knows, but it is a pretty unusual sort of beast. It applies New York law to the policy, albeit in a truncated form. It disapplies those rules of construction in New York which are triggered by perception of an ambiguity in the contract you're construing. The philosophy appearing to be that those are rules of construction such as reasonable expectations of the parties, contra profferentem, the use of parole and extrinsic evidence to resolve ambiguities, which tend to work badly for insurers in litigation in the States. And New York law is just argued typically in a Bermuda form arbitration. It's not proved in the usual way that foreign law is proved in an English court. And quite often it's argued by English barristers, usually with an American sitting next to them to make sure that they stay on piste. But the policy itself is unusual. It's not a conventional form of liability policy. It neither ensures claims made nor losses occurring. The two orthodox classic forms of liability insurance. It ensures occurrences reported. In other words, if you report the likelihood of claims arising from an occurrence such as Deepwater Horizon, then all future claims attach to the policy period in which the occurrence was reported. And that, of course, triggers some quite difficult problems. It means, for example, if you're a manufacturer who anticipates or has actually received claims attributable to a defect in your product, a pharmaceutical manufacturer is a classic case, you will continue to sell this product and you will continue to receive claims which will be expected or intended, and under classic insurance law would cease to be a fortuity for that reason. Now, the Bermuda form contains some quite complicated language to try and extract from future claims that element which is deemed to have been fortuitous or unintended, either in terms of volume or the nature of the claims. So it's not surprising that parties to Bermuda form references want to appoint arbitrators with some experience of the issues that this form of policy generates. Again, returning to the question of independence, the fact of the matter is, as apparent from the evidence below, that M was a very popular arbitrator and was popular for his expertise and ability and his experience in this type of arbitration. I should also say that...
I'm sorry to interrupt you, but just while we happen to have that American case in front of us, I just noticed that HN10, the very next paragraph, is the clearest possible explanation of the American attitude towards party-nominated arbitrators.
Yes, indeed, yes.
I just wanted to draw that to the attention of
yes, indeed, they have
panel.
different tests for what they call a neutral and a party appointee.
Yes, I'm sorry to interrupt you, but I thought it was worth noting that.
Your Lordship, of course, has my submission on that. That is one import from the States that we ought to resist as strenuously as we possibly can.
Yes, thank you.
Now, well, turning to a different topic, as we now understand Halliburton's case, and we respectfully submit it has gotten through a certain process of development as the matter has come up through the courts. The case, as currently presented, involves a presumption that acceptance of an appointment in an overlapping reference is unacceptable unless there is disclosure to the non-common parties and their consent is elicited. Now, if that is the position which they ask this court to adopt, one has to examine the implications. What is required in terms of relationship or overlap to trigger this presumption? Must it be identical issues, as we have, for example, in Guidant, or will related issues be sufficient? And if related issues are sufficient, how close a relationship will be required before this presumption is called into play? Must the issues be interdependent in the sense that a decision in reference 1 will logically entail the same decision in reference 2, assuming consistency of approach? Will common issues of law suffice, or must there be a factual or evidential overlap? And if so, how extensive must that be, and how critical to the outcome before the presumption is triggered? None of these questions are addressed. But if this court was to go down that avenue, the line would have to be drawn somewhere. And with respect, it's not clear to us where it would be drawn. Now, against that background, it's pertinent to note that the courts below looked at the actual degree of connection or relationship between the Halliburton and Transocean references and concluded that even in the event that the preliminary issue was decided adversely to insurers and the matter went to a full hearing in both references, the degree of overlap was relatively insignificant. It was small. And before I come to the references in the court below, I will, if I may, give you my submissions as to why those observations were entirely correct. Had the Transocean arbitration not been resolved on a preliminary issue specific to that case, the courts would have had to have considered the reasonableness of the Transocean settlement. That would have been the next central issue. But the reasonableness of the Halliburton settlement and the reasonableness of the Transocean settlement presented entirely different questions. Halliburton, as you'll know from reading the judgments below, settled, in fact, 2 days before, a judgment that everyone knew was imminent for $1.28 billion US dollars. So Halliburton had to make some assessment of the risk that judgment presented. In other words, what was the likelihood that their employees would be guilty of at least gross negligence? And in that case, what was the likelihood, what was the risk that would involve corporate liability for punitive damages under the relevant federal circuit law, the law of the Fifth Circuit? In contrast, Transocean settled after a judgment which had effectively exculpated them. Transocean were held 27% to blame, as distinct to Halliburton's 3%, thereby giving an indication of the differences in the involvement of the two parties. But they were entitled to an indemnity from BP, which the court held was enforceable in the circumstances. So they were effectively settling the risk of a successful appeal. And as you know, there were two curious, distinct features which differentiated the two cases. In the case of Halliburton, the settlement contained an opt-out exercisable by the plaintiffs, represented by the steering committee, for quite a lengthy period after judgment. So that gave them a one-way bet, effectively. And that's dealt with in the Halliburton award, a lengthy award, which you'll find in the S-files. I don't intend to take you to it. In contrast, the central issue in Transocean was whether the Chubb policy ever attached at all. And it's only when that was resolved, or would have been resolved against the insurer, depending on how you treated or deployed the $1 billion of fines and penalties, that the question of the reasonableness of the settlement was triggered at all, or could be triggered at all. Now, in those circumstances, we submit that Mr. Justice Popplewell was entirely right in saying that there was no close relationship, no material relationship between these issues at all. If one looks at Core Bundle 12, tab 12 at 222, that's 223 in electronic numbering.
Sorry, is this the judgment of Mr. Justice Popplewell?
Yes, my lord, at tab 12. At paragraph 52, where he refers to some submissions made by Mr. Kitchener on behalf of Halliburton. The overlap is contained in the defence advanced by insurers in each case that the settlement was not reasonable, and secondly, a number of coverage issues or issues as to loss of subrogation rights. As to one, the argument proceeds from an entirely fallacious allusion into a single issue of what are two quite distinct issues turning on separate fact and law, i.e. the reasonableness of two separate settlements on different terms, at different times, by different parties, owing different liabilities and facing different allegations. And the Court of Appeal deal with this, I needn't take you to it, but they just say there was no material or substantial overlap. That's at page 198, page 199, electronic numbering of the core, paragraph 96. That's just for your notes. So one asks rhetorically, why should the outcome of one of these arbitrations, even if it had run to its full course, have any impact or relevance to the outcome of the other? It's not like Guidant, where the same claim was made by the same insurer arising out of the same risk and the same loss at different layers of the insurance program. Now, my Lord, can I deal, again, I hope fairly swiftly, given the time constraints.
Mr. Crane, I'm sorry to hold you on.
Not at all.
To what extent would those features that you've just drawn to our attention have been known to M at the time he accepted the appointment?
They wouldn't. What M knew at the time he accepted the appointment is contained in his disclosure to Transocean, that he understands it arises out of a different aspect of what he described as the Deepwater Horizon incident. That was his state of mind. And, well, your Lordship heard my submission on why his disclosure to Transocean covered both his obligation, if any, and accorded with good practice, if indeed that's the governing criterion.
Thank you.
Now, I won't trouble your lordships and ladyships with this because they're all authorities that are obviously so well known to you, but I think it's uncontroversial that in the case of a judge in litigation, the fact that the judge has dealt previously with the same or a similar issue is not a disqualifying circumstance. There has to be some aberrant behaviour in the previous case which indicates that the tribunal has a closed mind. The closed or open mind are the relevant issues. And we have the classic passage of Lord Bingham's in Davidson, a Scottish minister, when he talks about judicial track records. We have Lord Bingham again in Lochaber, where he says the previous record of a judge will very rarely involve disqualification as regards trying the issue in question. I think my Lord Lloyd Jones was amicus in that case, so there's no need to remind you of that. Amec, where the same issue was tried twice between the same parties, when the first adjudication was annulled for some formal deficiency, and it was held that that didn't indicate a closed mind on the part of the tribunal. And the recent Court of Appeal decision in Okriti, which again pulls together the relevant authorities. So that's the position. And I apprehend that it's uncontroversial in the case of a judge in litigation, which of course is public. Although how public or well known the judge's previous decisions on any given issue are is a matter of happenstance. But it's said that the presumption is not applicable in arbitration, and we take issue with this. The test is the same. That's no longer in dispute, and was said to be the same by Lord Gough in the Crown and Gough, and again cited with approval in Lochaber. And the starting point we submit should be a presumption that a professional arbitrator will perform his or her duties under Section 33 of the Arbitration Act, that he will act fairly and impartially as between the parties and give each party a reasonable opportunity of putting his case and dealing with that of his opponent. And that involves deciding the reference on the basis of the material adduced in that reference. And if there is some extraneous driving factor, bringing that to the attention of the parties so they can address it. Now, this is not a question of saying M is a highly distinguished, well-respected arbitrator, albeit he was. It's a question of assuming that just as a judge will do that, so will an arbitrator. And indeed, he or she has statutory duties which require that approach to be followed. There's nothing parochial, nothing wrong, nothing insular about that presumption. And again, I can take this shortly. Halliburton effectively advances two reasons why the court should not apply that presumption in the case of confidential arbitrations. The first is the assertion that the common party in overlapping references will have the advantage of observing the tribunal's responses in the first reference and adopting its tactics accordingly in the second. I've dealt with the dress rehearsal point already, and I won't weary the court by repeating it. But even if that has some mileage in concurrent references dealing with identical issues, it doesn't apply in this case for the timing reasons and for the lack of overlap reasons that I've indicated. And again, one might ask, most tribunals consist of three. The ability to discern the response of a single arbitrator to a given issue before a substantive award is actually quite difficult, and quite often can be a trap rather than a useful guide. The second is that the non-common parties in both references are excluded from what is described as ex parte communications in the other reference, and to which we reply, they're not ex parte communications in any sense in which that word is understood. Communications between the tribunal and the parties in the Transocean reference had nothing to do with Halliburton. They weren't ex parte communications in the Halliburton proceedings. And ex parte communications in these proceedings is the language to which Lord Grabner referred yesterday when he invited your attention to the terms of appointment. They're absolutely irrelevant with respect. And so-called secret communications between an arbitrator and a party will occur, or will have occurred, whenever an arbitrator has dealt with the issue in question in a previous reference. It doesn't involve concurrent appointments. It doesn't involve appointments with one common party. It's just a fact and a possibility that with confidential arbitrations you have to accept. And that's actually an echo of what the Arias Committee were reporting on. And I hope I'll be forgiven if I can remind the court that in the Guidon case, Mr. Justice Leggett was quite clear that while in concurrent appointments involving identical issues in effect, you may not wish to appoint the same arbitrator under Section 18, he was quite clear that that did not give rise to an appearance of bias, such as to justify disqualification under Section 24. Now, may I deal with the Boomer case, in which some fairly considerable investment was made by Halliburton when it opened yesterday. The court will find that at Volume 1 of the authorities. Tab 7, page 76, or 950 in electronic numbers. Now, as Lord Grabner observed yesterday, this was quite a curious case. It was a case of concurrent adjudications. In one adjudication under this building contract, the subcontractor, Boomer, was seeking an award from Vinci, the main contractor, that certain compensation events had caused delay to the contract. And in the course of that adjudication, it was Boomer's objective and in their interest to advance the date on which certain sections of the work were operationally ready. Airport operational readiness is the term used in the report. Concurrently, they were proceeding against the subcontractor, Logan, seeking damages for delay, liquidated damages. In that adjudication, they were postponing the date on which the works were operationally ready and attributing that to default on the part of Logan. And there was Dr. Churn sitting in the middle of cases which involved inconsistent presentations on a crucial underlying issue, the same issue in both. Now, you'll see from the report, paragraph 13, that the The issue here arose in the context of the rules of natural justice, which have two limbs. First, that a party must have an opportunity to present his own case and meet the case against him. And secondly, that the matter is decided by an impartial tribunal. It is the second of those two limbs that concerns bias, both actual and apparent. And then in 14, the submissions concerning natural justice relied upon by Vinci encompass both limbs, although the first limb, in other words, denial of an opportunity to present your own case and deal with that of your opponent, is emphasized more than the second. So if one translates that or transfers it to the arbitration context, we would say that was a breach of the obligation to deal fairly as between both parties under Section 33 of the Arbitration Act. It was visiting unfairness on one of the parties, in fact, two of the parties, although they are not involved. And then if one goes to paragraph 25, you'll see that the judge, unsurprisingly, took a very dim view of the behaviour of Boomer in this case. Of advancing completely inconsistent cases on this same issue. And then at paragraph 33, again, I won't weary the court by reading out that paragraph, but the gist of it is that the adjudicator had powers to order disclosure, cross-disclosure in the two adjudications. And it was submitted, and the judge accepted this submission, that at least the pleadings could have been disclosed to the other adjudication, which would have revealed the inconsistency. So what we have here is an adjudicator who was faced with a conflict of interest, which should either have caused him to resign or to order the disclosure that would have cured the problem, perhaps not available to an ad hoc arbitrator, or to have sought some consent from the parties to deal with the conflict with which he was presented. So that was a case where, in the course of the adjudications, he encountered a disqualifying circumstance which should have either involved disclosure or resignation. So both courts below, I think, accepted that the actual outcome in Boomer was correct. What they didn't accept were the dicta of the judge suggesting that concurrent appointments in overlapping cases was, as a matter of principle, unacceptable without disclosure. Because both courts went the other way. They concluded that in principle, such appointments were acceptable. And I should also say that the problem, of course, in Boomer was not the result of the same adjudicator being appointed in both. Had there been two adjudicators, there was even less chance that Logan and Vinci would have realized what Boomer was up to. At least the commonality of the tribunal, one would normally have expected to provide some sort of disincentive to that sort of behavior. So it's a very curious case. Can I now deal with a point which is important conceptually and as a matter of principle, but may not affect the outcome of this particular appeal, and that is whether in English law there is a common law duty of disclosure, and if so, what is the content of that rule? Now, the starting point is the model law, and I'll explain in due course that it was the guiding precedent, albeit not adopted in its entirety by the draftsman of the Act. We'll find that in volume 2 of the authorities, at tab 45, page 468 in the paper bundles, 1342 in the electronic files. And as the court will know, this is not a treaty. It's a set of rules available for adoption or not by nation states. And the UK apparently had quite a prominent role in its drafting in the 80s. So Article 12 is grounds for challenge, and Article 12.1 establishes a rule of disclosure. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose any circumstance likely to give rise to justifiable doubts as to his impartiality or independence. And then there's a continuing duty of that nature. And then Article 12.2, which made its way into the Act in the shape of Section 24.1a, shorn of the reference to independence for reasons that I've already explained, is as follows: an arbitrator may be challenged only if circumstances exist that give rise to justifiable doubts as to his impartiality or independence, or if he does not possess qualifications, etc.
Can I just ask you, just in relation to that first sentence, I mean, one gets the impression from what we've been looking at that an American company like Halliburton would find it outrageous that a neutral tribunal chair, while simultaneously accepting a nomination from one of the parties in a different arbitration, because in the looking at it through American eyes, he's effectively Chubb's man. That would be the
Yes.
inference drawn.
Yes.
And so if we look at that first sentence, there are circumstances that would give rise to doubts on the part of an American party to arbitration as to the impartiality of the tribunal chair. Now, your argument is they're not justifiable doubts because we're not dealing with an American arbitrator conducting an American arbitration.
No, that's the first point, yes.
Yeah.
But I'm sorry, Muller, I didn't mean to...
No.
But the second point is that, of course, your Lordship has highlighted the difference between doubts in the mind of a party, a subjective test, and doubts in the mind of the objective observer, which is the test under English law. And both English law and indeed the rules of the LCIA and the ICC, and I think any other institutional rules one cares to mention, make the difference between, the crucial difference between those two tests. And indeed that's central to Lord Hope's description of the attributes of the notional fair-minded observer in Hilo.
Yes.
That it's not to be confused with the parties.
Your fair-minded observer isn't an American.
No, certainly not. No.
And
Well, yes, it could be an American experience in international arbitration. But here, of course, K&L Gates knew the ropes, even if Halliburton didn't.
yes,
But so, my Lord, it's clear in our submission that Article 12.1 of the model law is referring to the objective test, as indeed is Article 12.2.
Yeah, and so it perhaps isn't the easiest of lines to tread, but really on your approach to this, even although there may be American parties to a London arbitration instructing American lawyers, and there may be American arbitrators, London arbitrations are to be under principles of fairness in relation to London arbitrations are to be looked at in terms of English arbitration culture.
Yes, absolutely. And indeed, in the case of A and B, Mr. Justice Flo, I'll come to this later, in the case of A and B, Mr. Justice Flo, referring to previous authority on this, says in terms the nationality, it's nationality blind. The objective observer is imputed with knowledge of the local culture. He's not a lawyer, or she's not a lawyer. It's a female in Hilo.
Yes.
But knowledge of the legal scene.
Yes.
And that's very important.
Yes, I mean, obviously that's not the only point in the case, but
Yes.
so far as I wanted to get your position on that. Thank
Absolutely.
you for that.
And indeed, when you hear from Mr. Landau, and I hope that will be sooner rather than later, he will tell you that that is internationally accepted. America is an outlier in that respect. So if we can then just look at a passage from Mustall and Boyd, which I'm referring to establish the attention which the draftsman, the attention paid by the draftsman to the model law. That's at volume 7 of the authorities, tab 190. At page 3135. And of course, Lord Mustall was initially... Oh, I'm so sorry. It's tab 190, page 2261, paper bundles. Yes, I'm afraid so. Mine was cut off. Lord Mustall, of course, was initially chairman of the Departmental Advisory Committee, and then his successor was Lord Savile. And Lord Steyne, then Lord Savile, sorry. And if you can pick it up on page 3135, 2261 paper bundles, just after the first paragraph break, the shortcomings of the existing law were obvious.
Yes.
And then there are a number of options, including adoption in toto of the model law.
Sorry, on page 3135.
2261, but unfortunately
Well, that is 22. That is.
yeah,
But where on
mine has been
the
cut
page?
off, and probably yours has as well. Yep.
Thank you.
Yep. Shortcomings of existing law. That just sets the scene, really. And it concludes by saying it was the task of the DAC to advise ministers on which choice they made. And then, perhaps more importantly, in the event, the DAC presented a composite recommendation to the effect that the UK should not apply the model law to England, but should replace the existing statute law with an ambitious new statute, having the characteristics set out in paragraph 108 of the DAC's first report, and you'll see that in the footnote. And then I'd like to pick up in particular 1 and 7 of the characteristics. It should comprise a statement in statutory form of the more important principles of the English law of arbitration, statutory, and to the extent practicable, common law. 5, we should look at, it should not be limited to the subject matter of the model law. And then 7, consideration should be given to ensuring that any such new statute should, as far as possible, have the same structure and language as the model law, so as to enhance its accessibility to those who are familiar with the model law, give it some international accessibility. And then section C on the next page, 3136, 2262, as we have said, the UNCITRAL model law was one of the principal inspirations of the 96th Act, and both the shape and the language of the two instruments are in important respects the same. So we submit on the basis of that the decision to omit from the Arbitration Act 96 a statutory rule of disclosure, while at the same time incorporating in effect Article 12.2 of the model law, was a deliberate omission. And we also submit that if one looks at the common law rule of disclosure formulated by the Court of Appeal, which is an obligation to disclose circumstances which could or might arguably give rise to an apprehension of possible bias in the mind of an objective observer, that rule of disclosure is wider and more demanding than the rule of disclosure formulated in Article 12.1 of the Common Law. Yes, the modern law. So it would be paradoxical, we submit, that having decided not to include a statutory rule of disclosure, the effect of which is to compel disclosure only of circumstances likely to give rise to an apprehension or discernment of bias. By the indirect route adopted by the Court of Appeal, arbitrators are burdened with a wider common law rule of disclosure, namely to disclose circumstances which might arguably or could give rise to the same apprehension.
Well, one inference from the omission of the legislature to enact a provision is that it wishes the common law to develop and not to be ossified within a statute, so that it may have been so in 1996 of the date of the DAC report, that the disclosure duty was somewhat less than it has evolved to be subsequently.
Well, my lady, I accept in principle that the common law is a developing body of law, but I would respectfully remind the Court of the passage to which I referred in Mustel and Boyd, that the aim of the Act was to capture as far as possible the common law applicable to arbitration. So certainly at the time of the Act, 1996, that represented the position. Now, of course, Scotland took a different route. Can I just give your lordships the reference in the papers, because it's not obvious where the Scottish rules are. It's Intervenors, Volume 3, Tab 14, 787 at 788. Perhaps we should look at it very briefly. And as I said yesterday, this is a schedule to the 2010 Arbitration Scotland Act. And at Rule 8 on page 787, electronic 788, provides a statutory rule of disclosure. This rule applies to arbitrators, individuals who've been asked to be an arbitrator, and then in 2...
Sorry, you're at Rule?
It's Rule 8, my Lord.
Rule 8, thank you.
Yep. 8.2 requires or compels an arbitrator or someone about to be appointed as such to disclose any circumstances known to the individual or which become known before the arbitration ends, which might reasonably be considered relevant when considering whether the individual is impartial and independent. But interestingly, the test for removing an arbitrator in Scotland appears to be substantially more demanding. If you look at Rule 12, the Outer House may remove an arbitrator if satisfied on the application by any party that the arbitrator is not impartial and independent, that the arbitrator has not treated the parties fairly. So in a case such as the present, you'd have to ask, are you satisfied that Halliburton has been treated unfairly? And then Rule 13 enables the Outer House to dismiss a tribunal for breach of these rules, presumably including Rule 8, disclosure, but only if a party shows that substantial injustice has been or will be caused. And then Rule 77 tells you what independence is taken to mean in this context. In effect, it's independence giving rise to partiality or giving rise to justifiable doubts as to impartiality. So then that's a good example of a case where a breach of even a legal rule of disclosure is well short of giving rise to circumstances sufficient to justify removal of the arbitrator. And obviously, that envisages a two-stage test. Now, my Lord, I won't take your lordships to this given the time constraints, but the articles to which Lord Grabner referred yesterday contain some quite interesting discussion on whether the rule of disclosure formulated by the Court of Appeal or a statement of good practice is more desirable or logical. And in the Hancock article, the reference is A, Volume 7, Tab 175, 2172, and that's a paper number. I'm afraid I don't have the electronic number for that. And in the McKendrick article, it's A, Vol 7, Tab 170, 2126 at 3000. And Professor McKendrick suggests, he points out to the fact that a rule of disclosure doesn't appear to have any consequences visited on breach, but he says not too much should be made of that, because even in jurisdictions where there are such rules, for example, model law jurisdictions such as Australia, that is the position. But he then suggests that possibly a precept or rule of practice giving rise to expectation that it will be followed may be more suitable. So I will leave that for the court to read. Now, significance of failure to disclose. The crucial point is that whether there's a failure to disclose and whether there are grounds for removal of an arbitrator are entirely distinct and different questions. And if you answer the first question in the affirmative, then that may be a factor influencing your decision on the second. But we then have to ask how prominent or weighty a factor that will be in a case where the omission is entirely inadvertent, known to be innocent, and the vice alleged is that it was an omission to mention a circumstance that might have involved unfairness to Halliburton, but which in the event did not. In other words, as it's found by the Court of Appeal, non-disclosure of a non-disqualifying circumstance where the non-disclosure was itself innocent. And we would commend to the court a passage in the judgment, the speech of Lord Mance in Hilo and the Secretary of State for the Home Department, which with court's leave I'll look at briefly. It's in A1, tab 11. Uh, 137 in the, that's the head note, but the passage I want is at 155. Sorry, it's at 156. Electronic, please. Electronic 1030, my lady. And the court will no doubt be familiar with the facts of this case. This was a motion by an asylum seeker to remove or have disqualified the Lord Ordinary for her membership of an association, the International Association of Jewish Jurists and Lawyers. And that was refused. But Lord Mance, at paragraph 58, says this: the other consideration, 58, is that Lady Cosgrove did not volunteer a reference to her membership of the association. Had she disclosed this, the very fact of disclosure could have been seen by a fair-minded observer as a badge of impartiality, as showing that she had nothing to hide and was fully conscious of the factors which might be apprehended to influence her judgment, reference to Lord Bingham in Davidson and Scottish Ministers, and Lord Hope in the same case. Again, however, this can only be one factor and a marginal one at best. Thus, to take two opposite extremes, disclosure could not avoid an objection to a judge who, in the light of the matter disclosed, clearly ought not to hear the case, and non-disclosure could not be relevant if a fair-minded and informed observer would not have thought that there was anything even to consider disclosing. In the present case, I do not consider Lady Cosgrove's failure to disclose her membership of the association to be a factor which could carry any great weight in the balancing of factors which a fair-minded and informed observer must be assumed to undertake. A fair-minded and informed observer would, I think, be much more likely to conclude that it never crossed her mind that her membership involved anything which it was relevant for her to disclose. And we would submit, again, referring to the material to which I referred yesterday, that it never occurred to M to disclose to Halliburton what he disclosed to Transocean, because it was Transocean, if anyone, who stood to be interested, and if anyone stood to be disadvantaged. Now, I won't take the court back to them, but the Court of Appeal cited those passages from Davidson and other judgments. I think it's at paragraph 56 to 63 of the judgment, which, in its opinion, form the basis for a common law rule of disclosure. And my submission, and we don't need really to go back to them, the passages are there, is this, that when one looks at the language, what those passages are describing or recommending, stressing its importance, is a desirable practice. The desirable practice of disclosing any circumstance which could arguably give rise to an apprehension of bias, if only to demonstrate the badge of impartiality to which those dicta refer. And it's Davidson, it's Taylor and Lawrence, it's Lockerbale and Al-Mazidi. My Lord, can I now address the proposition that I mentioned yesterday, that in this two-stage inquiry, the second stage involves consideration of all material and circumstances known to the deciding court at the date of the relevant application. And it's perhaps particularly important in a case such as the present, which is the allegation of exposing Halliburton to a potential unfairness which never materialized in circumstances where the non-disclosure was entirely inadvertent. So if you draw the line where Halliburton want to draw the line, you do injustice in a case such as this. And you apply an approach which we would describe as mechanistic and formalistic. Now, the first case is Porter and McGill. Again, a very brief reference to the passage in question. Authorities, Volume 1, Tab 16, 267, in the paper numbering 1141, electronic numbers. And in paragraph 102, you'll see a reference to the judgment of Lord Phillips, Master of the Rolls, in a case called Medicaments and Related Classes of Goods. And at the indent at paragraph 85, you'll see that passage of the judgment, which was then adopted by the House of Lords in this case. And it reads as follows: when the Strasbourg jurisprudence is taken into account, we believe that a modest adjustment of the test in Goff is called for, which makes it plain that it is, in effect, no different from the test applied in most of the Commonwealth and in Scotland. The court must first ascertain all the circumstances which have a bearing on the suggestion that the judge was biased. It must then ask whether those circumstances would lead a fair-minded and informed observer to conclude that there was a real possibility or a real danger, the two being the same, that the tribunal was biased. So that involves ascertaining at the second stage all the circumstances bearing on the issue in question. Now, in AT&T and Saudi Cable, which the court will see at tab 18 of the same volume, a case where, again, there was inadvertent non-disclosure, but in all the circumstances, the judgment of the Court of Appeal was that no case of apparent bias was made out. If one looks at page 322, 1196 in the electronic files, at paragraph 63, the court sets the test for apparent bias and quotes Lord Gough as saying, "The law has first ascertained the real circumstances from the available evidence, knowledge of which would not necessarily be available to an observer at court." That being a criminal case where the issue was possible relationship between a member of the jury and a relative of the accused. And then at 64, this is the...
I'm sorry, before we leave 63, there's a sentence a little bit further up, where it say that it's not in dispute that reasonable apprehension of bias is a test in which reasonableness is judged by the standards of reasonable objective observer. Then it's the next sentence. That is in reality the court itself embodying the standards of the informed observer, viewing the matter at the relevant time, which is, of course, the time when the matter comes before the court.
Indeed. Indeed.
But if it's alleged that it's a matter, that the matter being complained of is a breach of the duty of disclosure, do you not have to consider the circumstances at the time of the alleged breach?
You do, my lady, certainly on issue 1. In other words, whether there was a breach of disclosure, and if so, what the implications were. But then you have to go on and ask whether or not, in all the circumstances, there's a real possibility or a real danger of bias or justifiable doubts exist as to the impartiality of the arbitrator. And at that stage, you can take into account all circumstances known to the court at the relevant date.
So the answer could change, that even if there were a reasonable apprehension of bias at the time of the appointment, by the time the court comes to consider it, further facts have come to light which show that there is no longer a reasonable apprehension.
In other words...
That's what you're saying.
Yes, absolutely. In other words, circumstances at the time of the obligation to disclose accrue may have caused a bystander to have suspicions, which will be allayed when all the circumstances now available are taken into account.
Would that create an incentive not to disclose in the hopes that the facts may change favourably to the person who arguably is under the duty?
Pretty risky course to take, my lady.
But it's one way.
Well, that would be a very odd psychological state for an arbitrator to say, well, I won't disclose, I just hope that by the time this matter comes to court, circumstances will have materialised which will enable me to mitigate the effects of my breach of duty. Yeah, and of course, as is clear, that would be a deliberate, illegitimate non-disclosure made for a bad reason.
It wouldn't necessarily... Sorry.
I'm so sorry, I didn't mean to
cut in, Mr. Crane.
Yeah, I was going to say that's quite a good example of the circumstances in which the non-disclosure itself and the state of mind which drove it may give rise to an appearance of bias.
In AT&T, did anything turn on the date at which the assessment is made?
Yes, I think it did, in the sense that what it took into account, and I know this is challenged as legitimate under the modern system, is it was the reputation of the arbitrator, and the fact that the non-disclosure was inadvertent. What the court did was look at all the circumstances bearing upon that.
Thank you.
I think our interruptions before you got to paragraph 64 may have anticipated the point that, in fact, is going to be made in paragraph 64.
Yes, it right. But I hope the court, now having read it,
we
will have
couldn't contain our excitement.
Well, paragraph 72, the court says, nevertheless, if I'm wrong in that respect and breach can be demonstrated, it does not seem to me to be one which could possibly justify the removal of Mr. Fortier as an arbitrator or the setting aside of any of the awards made. So far as the non-disclosure of his directorship of Nortel was concerned, that was a competitor to AT&T in the bidding process. It was entirely inadvertent. Furthermore, as we have held, no suggestion or real danger of partiality arises or has been substantiated, nor has any disadvantage in the course of the arbitration been demonstrated. So it's a pragmatic approach, looking at the matter holistically and asking whether or not the circumstances justify the serious step of removing an arbitrator. And one can see at paragraph, the top of page 317, electronic 1191, a dictum of Sir Thomas Bingham, as he then was, in a case called Delalio, referring to the Goff decision and saying that the description of apparent bias traditionally given to this head is not entirely apt, for if, despite the appearance of bias, the court is able to examine all the relevant material and satisfy itself there was no danger of the alleged bias having in fact caused injustice, the impugned decision will be allowed to stand. The famous aphorism of Lord Heward is no longer, it seems, good law, save, of course, in the case where the appearance of bias is such as to show a real danger. And then Sir Sidney Kentridge for AT&T, who was seeking removal, criticised both of these statements. Mr. Pollock, for the respondent, is more accurate when he submits that both the real danger and the reasonable submission test subsume the test laid down by Lord Heward. Unless there is some foundation for saying that justice has not been done, it is seen to be done. The court, and then 3 lines from the bottom, the court considers on all the material which is placed before it whether there is any real danger of unconscious bias on the part of the decision maker. Now, again, with the time constraints very much in mind, can I just give your lordships possibly the clearest instance of this approach being applied? It's a case called A and B. It will be found in Vol 2 of the authorities bundle at tab 61, page 580, 1454 in the electronic files. And that was another case involving a barrister arbitrator, where in the course of the arbitration, a case in which counsel was instructed by solicitors to one of the parties revived. The barrister overlooked disclosing that. It involved him dealing with that team in the course of the arbitration as he prepared for trial. And when he was about to issue his award, on I think the 3rd day of the trial, it occurred to him that he ought to mention it, which he did, and there was then an application to remove him. Now, it was argued that the non-disclosure of the fact when the case revived at an earlier stage, and he once again became instructed by the legal team to one of the parties, that the non-disclosure of that fact should have caused his removal, addressing, I think, Lady Arden's point. And the issue then arose as to whether or not you could consider what happened subsequently. The suggestion was that unconsciously the barrister would be biased in favour of solicitors he was working with in the course of preparing for trial because he would get to know them. And in the event that in the arbitration there was some application which called into question the credibility or integrity of the solicitors, for example, disclosure of documents, he would tend to rely upon their integrity illegitimately. And the fact was that no such application had arisen. In other words, there was no opportunity for that possibility to have asserted itself. And one can see on this the submission made by Mr. Stanley, for it is he, at paragraph 43, and the acceptance of that submission by the court at paragraph 67. If we just look at 43, Mr. Paul Stanley, for the defendants, emphasised the point I referred to in my analysis of the applicable legal principles, namely that the relevant inquiry is into all the factual circumstances as they appeared to the court at the hearing, not, for example, as they might have appeared in November 2009 when the disclosure ought to have been made. In other words, the court must take into account the known facts which demonstrate that some of the aspects of unconscious bias identified by Mr. Milligan as examples are simply not applicable. There is thus no evidence that X inadvertently let slip some comment about the arbitration, or that he had to defend the conduct of Dewey in the court case or criticise them in the arbitration. And then at 67, the judge accepts that, on the basis of the material before the court, Mr. Milligan's third and fourth aspects of unconscious bias, and then he describes them, simply do not arise, while viewed at the time when he was re-instructed in November 2009, and when on the claimant's case he should have disclosed such re-instruction, these matters might have been ones of potential concern. It's clear on the authorities to which I've referred that the question of apparent bias is to be judged at the time of the application before the court on the basis of the material now available. And there's a lot to be said for that, because it does justice in cases where there's an inadvertent, innocent failure to disclose something which actually does the applicant no harm at all.
Yes, the use of the present tense in section 24(1)(a) might support that.
Indeed.
Yes, it talks about applying to remove an arbitrator on the ground that circumstances exist.
Indeed. My Lord, I'm conscious that the court will want to hear from Mr. Landau on this. I haven't dealt with the IBA guidelines, but perhaps I could sub that to him at some stage.
Well, we do also have very full written cases on behalf of all parties.
Indeed, indeed.
Thank you. Yes, Mr. Landau.
Yeah, sure.
The court, there has been much emphasis by Halliburton, also echoed to different degrees by the ICC, the LCIA and the Chartered Institute, that the approach of Mr. Justice Popplewell and that of the Court of Appeal and that of Chubb is out of line with international practice and is a threat to London's future as a leading international arbitration seat. Those are concerns which obviously are of importance to consider. In my respectful submission, that is simply not the position, neither on issue 1 nor on issue 2. If I can deal with those issues in turn, I've got more to say on issue 1 than issue 2. On issue 1, there are two camps, broadly, now before the court. The first one is Halliburton alone. Halliburton's position now is that there is a presumption that the fact of accepting an appointment in the circumstances of this case will give rise to justifiable doubts. But that, as we understand it, is a rebuttable presumption. And we have so far a few, perhaps vague, indications as to when it might be rebutted. It's been suggested if there are specialized rules in place, such as the LMAA or GAFTA. We're not told, however, whether that means the rules are actually implemented, actually activated. And secondly, if there is disclosure and consent or waiver. The reference to how that was encapsulated by my own friend Lord Grabiner yesterday is the transcript, page 16, line 5, to page 17, line 20. So that's the first camp, a presumption. The second camp is actually everybody else. That is Chubb, as well as Mr. Justice Popplewell, the Court of Appeal, the LCIA, and the ICC, which is that there is no such presumption. Rather, as put by Mr. Justice Popplewell, the Court of Appeal, and in our submission, the fact of accepting such an appointment is not enough itself. You need something more. And as put as a variation, perhaps, of that by the LCIA and the ICC, it all depends on the facts of each case. So the question is Halliburton's position in its lone camp actually supported at all internationally? And the answer is it has no international support. And that really isn't overstating it. The only support that actually was cited by my learned friend Grabiner yesterday, with all due respect to those concerned, are 4 individual commentators and 1 US law firm, Covington and Burling, which acts exclusively for policyholders. My friend didn't take you to any international authorities, and there is a wealth of material, as you'll notice by the number of trees that have suffered in the course of these proceedings. The Chartered Institute is also deployed, but the Chartered Institute also has not engaged with the international jurisprudence that we have set out in detail. So I want to, with the court's indulgence, go on a whirlwind fast tour through a number of different leading jurisdictions to give you at least a flavour of how this issue has been addressed, because it's been addressed in extenso. Before doing so, may I just make a few initial points about the nature of this presumption, because it rather explains why you do not find it recognised in any other jurisdiction. Firstly, this would be a major change to the IBA guidelines. The IBA guidelines, as the court may recall, has a system of red, orange, and green lists. In the orange list, Article 3.1.5 is that, and I'm quoting, the arbitrator currently serves or has served within the past 3 years as arbitrator in another arbitration on a related issue involving one of the parties or an affiliate of the parties. That is on the orange list. So that's squarely, the other side is saying that's squarely this case. It's a related arbitration with only one party being involved. But it's on the orange list. Perhaps I can ask you just to turn this up briefly. It's in the second volume of Authorities, tab 48, from page 478, electronic 1349. So one finds the orange list at paper 506, electronic 1380. Sorry, it begins the page before that. (506) 1380, you'll see Article 3.1.5, which is the one I read out. That is explained in commentary to this part of the IBA guidelines, which you will find at the bundle page, paper reference 501, electronic 1375. And that is paragraphs 3 and 4 of the introduction to part 2. The court has that. From paragraph 3, the orange list is a non-exhaustive list of specific situations that, depending on the facts of a given case, may, in the eyes of the parties, give rise to doubts as to the arbitrator's impartiality or independence. But importantly, if you then look at paragraph 4, disclosure does not imply the existence of a conflict of interest, nor should it by itself result either in a disqualification of the arbitrator or in a presumption regarding disqualification. That point is elaborated further in paragraph 5. A later challenge, based on the fact that an arbitrator did not disclose such facts or circumstances, should not result automatically in non-appointment, later disqualification, or a successful challenge to any award. Non-disclosure cannot by itself make an arbitrator partial or lacking independence. Only the facts or circumstances that he or she failed to disclose can do so. So that echoes the two-stage test that Mr. Crane has already identified and explained. But what is also important here is that the circumstances in question were placed by the IBA in orange, not red. But what's being put to you now by Halliburton is that that's wrong. They are now putting this into what's unhappily called the waivable red list. The waivable red list is explained on the previous page at paragraph 2. Electronic 1374, paper 500. Paragraph 2, the red list consists of two parts, non-waivable red list and waivable. These lists are non-exhaustive and detail specific situations that, depending on the facts of a given case, give rise to justifiable doubts as to the arbitrator's impartiality and independence. That is, in these circumstances, an objective conflict of interest exists from the point of view of a reasonable third person having knowledge of the relevant facts and circumstances. And that's distinguished just further down the paragraph from the orange list. Just a few lines down, the waivable red list covers situations that are serious but not as severe. Because of their seriousness, unlike circumstances described in the orange list, these situations should be considered waivable, but only if and when the parties, being aware of the conflict of interest situation, expressly state their willingness to have such a person act as arbitrator. My lords, my ladies, that is in terms how Lord Grabner put his case yesterday. So, according to Halliburton, the IBA guidelines are wrong. This situation actually should be in a different part of the IBA guidelines. That is not what the IBA found, firstly in 2004, when it first drafted these guidelines, and it didn't so conclude in 2014, when it looked again at all of these, and revised the guidelines. This would put England apart from all the other countries who are now looking at and following the IBA guidelines. Now, if I can just make a few more points, I know we're heading to a break, but just before that, if I may. It is worth considering the importance of this alleged presumption and its extent. The presumption gives rise to a veto to one party of the other side's appointed arbitrator. According to Halliburton, one party can have its chosen arbitrator only if and insofar as the opposing party consents. That is a dramatic restriction. Importantly, it's a restriction without any clear guidance, as Mr. Crane has already explained, as to when that applies. What is the degree of overlap? And of course, that will be critical to understand the precise parameters of that restriction. But the logical extent goes much, much further, because this presumption is driven by a number of individual concerns such as secret communications, the ability to have a dress rehearsal before an arbitrator, the ability to get inside the arbitrator's mind beforehand, where the other party can't do so. Now, I'm abbreviating what was perhaps a longer list. Those drivers apply in my submission with equal force in many situations in arbitration. Also in court, but I'm restricting myself now just to arbitration examples. What will be the fallout of this presumption? This will apply not only to parallel proceedings, but also sequential. They are as valid when a previous arbitration has completed as they are when two arbitrations are continuing in parallel. If you've already had an insight in a concluded case previously, and that insight is not shared with your opposing counsel or party, you have an imbalance. So we're looking now at any situation where you might previously have been able to get that individual ex parte so-called access to an arbitrator's way of thinking. But it applies then to the same legal argument. It's not restricted to facts. You can run arguments previously before a particular arbitrator on any legal point and dress rehearse how you're going to put that legal argument in another case. It applies to procedural issues. This is terribly important in my submission in arbitration. It's not just merits. You can have a dress rehearsal before an arbitrator on disclosure issues, on issues such as the treatment of privilege of documents, on any procedural matter that might be contentious where you're going to make a similar argument later. Of course, in arbitration, there isn't a white book. So all of this is up for grabs, and you will want to make your points and argue them in the same way as you would on the legal merits. Again, this will stop an arbitrator from sitting in a subsequent case where that procedural issue has already been argued previously, and there's been a dress rehearsal or some so-called ex parte communication on the issue. This will extend logically to counsel as well as parties. Why shouldn't it? If counsel has also had access to an arbitrator's way of thinking in a previous case and can share it in a subsequent case, on my learned friend's submission, that would be an inequality. And it also applies to the same party, even in different cases completely. Let me give that an example. You could have a state that appears before a particular arbitrator. And in the course of the arbitration, the arbitrator gets to understand the way that the state enacts policy or behaves. That is something which will have been worked out in that case to the exclusion of a party perhaps in a subsequent case. If that state appears again before that arbitrator, there will already have been an understanding as to how the state conducts itself. The claim may be different, the facts may be different, but there would still be an inequality because there will be some sort of history between those parties and some understanding already that won't be necessarily shared. One can go on with the list. And what happens if one does go on is one then treads into the IBA green list. There are many instances, if one were to look at the green list, that would actually become red list, waivable red list matters on the learned friend's case. I give one example. Counsel having acted previously as a co-arbitrator with the arbitrator concerned for one of the parties. Again, you would get into a situation where counsel has had an intimate exposure, as it were, to a way of thinking of an arbitrator, because they've sat together previously. That's a green list matter on the IBA rules. It's difficult to see how that could be sustained. Now, where this takes us, in my respectful submission, is that if the court were to go down this track, you firstly have the significant difficulty of drawing lines. But secondly, you have a major chilling effect. Anybody who comes to London to arbitrate, any arbitrator accepting an appointment in a London-seated arbitration, unlike any other seat, would be walking in a minefield at this point. If there was any possibility, any risk of same counsel, some kind of overlap, substantive or procedural, some issue about familiarity with the questions that may be in dispute, you wouldn't want to take the appointment. You'd be running a risk. It will do serious damage to the principle which was set out in the DAC report. It was read to you yesterday. I just give you the reference, paragraph 103 of the DAC report, electronic page 897, volume 1, tab 223. The DAC was concerned to preserve circumstances where, and I'm quoting, parties desire their arbitrators to have familiarity with a specific field rather than being entirely independent. And in my submission, that will drive people away from London. That may be a convenient moment for...
Yes, certainly. Thank you. I will sit again in another 5 or 10 minutes. Mr. Landau.
Well, ladies, I'm sorry to start with a housekeeping matter. There is some concern on the part of learned friend Lord Grabner about time.
Yes.
He would like to have an hour and 10 minutes for his reply.
Yes.
So about 4 minutes to cover the world's position. I'm wondering whether...
Well, I think you're supposed to, according to my timekeeping, you're meant to have until 5 to 12, and then Lord Grabner then has the rest of the morning.
Well, yes, I think strictly it was 10 to 12, but I'm very content to accept 5 to 12.
Well, I'm wondering whether there's any indulgence I can give, if it's of assistance to the court, simply because the court has been presented with a very important submission, which is that whatever this court decides will have an impact on the future of London. That has got to be tested by reference to comparative materials.
Yes.
It's a huge amount. I'm conscious you have written cases already. My hope was to give you some guidance in a map through that material. It takes a little bit of time.
Yeah. Well, you do have to finish on time. I mean, we operate on the basis that there is an agreed timetable and both parties have to stick to it. So just take it as quickly as you can, and obviously we do have the appendix to your written case.
Yes. I'm grateful. Just a few very quick points. Finishing off firstly on the IBA guidelines, the court will recall Article 3.1.3 of the Orange List, that the arbitrator has within the past 3 years been appointed as arbitrator on 2 or more occasions by one of the parties or an affiliate, and the court will recall there is a footnote 5 to that, which is a carve-out for specialised sectors. That is paper reference volume 2, tab 48, page 505, electronic 1379. Secondly, I've been asked by the Chartered Institute to qualify what I said just before. I had said in my opening shot that the Chartered Institute did not engage with the wealth of international material. They would like me to draw attention to footnote 10 of their intervention, where they say they do so engage. The point about the wealth of authority that's before the court is that the issues now identified by Halliburton, including the incremental risks of imbalance of information, secret communications, has already been addressed internationally. This is something of a chestnut. It's been addressed in commentaries, authoritative commentaries. It's been addressed in court decisions, and it's been addressed in institutional rules, decisions under institutional rules. Nowhere can one find this presumption. On the contrary, if I can just divide that up into 3 different groups. Firstly, commentaries. Secondly, leading cases. And thirdly, institutional practice. On the commentaries, one can go to, for example, and I'm afraid because of the lack of time, I now have to just give you, I think, a list of references. I'll just give you some key ones as a sample. So Craig, Park and Paulson, bundle A7, tab 165, from page 2085, electronic 2959, a leading commentary on ICC arbitration. It recalls the frequency of this situation of related appointments, even with just one party. For example, the construction world. It then emphasizes the right of a party in arbitration to select an arbitrator. It's not qualified, and concludes that this is not problematic to have parallel appointments in this scenario. That is echoed, and forgive me if I'm paraphrasing now quite a high level.
Yeah.
It's about time. Echoed, for example, in Gary Bourne's authoritative commentary on international arbitration from 2014 in its 2nd edition, bundle A7, tab 172, from page 2140. That is electronic 3014. Mr. Bourne identifies the kinds of concerns that Halliburton is now articulating and dismisses them, based upon a wealth of footnoted references. And then we get more regional commentaries, not just Anglo-US ones. Austrian, bundle A8, tab 196, from page 2307, electronic 3181. Philip Hanosch's commentary on Austrian law. The same. We have Poudret and Besson, which is a leading Swiss textbook on international arbitration practice. Bundle A8, tab 198, 2365, electronic 3239. Now, I can go on, but that just gives you just a sample. That's the first part. Now, what about actual court decisions? We have, in the course of our written case, given you a world tour of leading arbitral seats. And my plan was to take you through those decisions, because again, you will find these issues of alleged inequality, the risk of prejudice, all articulated, and it's water under the bridge. If I can just give you, I'll give you, and forgive me for this, a list of some references. Let's start with Austria. Austria, you will see a very relevant challenge. It's bundle A5, tab 107, from page 1428. And that is electronic 2302, a case of parallel appointments involving one party, assertions as to inequality of information, an imbalance, an undermining of the adversarial system in arbitration. And the Vienna court is very clear to say there's no objection. On the contrary, there are positive reasons in arbitration to have parallel appointments. Those positive reasons are important because the damage that will be done by the position for which Halliburton is contending is actually to established practices where benefits are felt, and there are reasons for doing this, and that will be undermined. Australia, there is a very helpful decision of the Supreme Court of Victoria, Court of Appeal, in a case called Gascore Trading. It is volume A5, tab 104, 1368, electronic 2242. Gascore goes into detail, and this is an example of many where the overlap was not disclosed. So these are not just cases where everybody knows about it and it's then tested. These are cases where it's on all fours with the allegations in this case. The party is coming to court saying we never knew about this, and there's an overlap, and that's problematic. Gascore, the Court of Appeal held, firstly, that there's no legal duty under the domestic arbitration law, which is not the model law in Australia. It's just a precept. But secondly, it was not problematic. There was no problem of prejudgment. Prejudgment would only be a problem if you actually look at the extent of the overlap, and they made a distinction between incidental and critical findings. It's not problematic if the arbitrator has already made incidental findings, perhaps on a particular document or context or background. It might be problematic if there are critical findings that have already been made, such as to render prejudgment very likely. And again, forgive me, I'm paraphrasing. I'm told it's time, so I'm in the court's hands, but the tour would take you further in a similar respect all around the world.
Yes.
And it takes you through France. The French cases are particularly important. Can I give you this reference? The Cour d'appel of Paris in the Crichton-Qatar case, which the French courts have always been extremely sensitive to inequality in arbitration as a public policy question. And in this case, in a very similar situation, all these doubts were debunked. They had no traction. Bundle A5, tab 106, page 1409, electronic 2283. And what's important in the Cour d'appel reasoning, which you then see reflected in all the other French cases you have, is that they are saying there is no rule against this. And then they go on to have a look at the particular situation. So what they're saying is no presumption. My lords, my ladies, the tour would have gone through Portugal, it would have gone through the US, and it would have ended up in China. And all those references you have actually embedded in all the footnotes, and it's all the same throughout. Very quickly, lastly, institutional.
I think we better leave it there, Mr. Landau. You can take it. You can take it. We have read the written case, and we'll be studying it further. Thank you very much indeed. Lord Greville.
Lord, in the United States Supreme Court on these occasions, a red light goes on in front of the advocate, and the Chief Justice tells the advocate to sit down, even where the application is being made on behalf of the President of the United States, as I recall. My Lord, perhaps that's a good device for your lordships to think about.
Yes, it would also help if we had a clock that worked. I'm afraid my eye was on that one over there.
My learned friends were relying upon the possibility that you would have been relying upon that clock, and we would have been here for 24 hours. My Lords, my first point really, and I've got a number of points and I'll try and deal with them as fast as I possibly can, is that apart from one passing reference, my friend Mr. Crane made absolutely no reference to Al-Mazidi. We regard Al-Mazidi as being an absolutely key case in the whole of this appeal. The explanation for that is either that he thinks it's irrelevant or that he's got no answer to it. In my submission, he obviously has no answer to it. It's all about apparent bias, and it is inconceivable that the point escaped, obviously, his attention. Then my friend's primary argument deployed yesterday, and so one might reasonably assume his most important and best argument, was concerned with the timing question in relation to the facts of the case. And the thesis of his argument was that any prejudice would be suffered in this case not by Halliburton but by Transocean. That point, if there's any force in it, was one which escaped the attention of the learned judge at first instance, the Court of Appeal, and all the commentators. And what my friend sought to do was to construct a factual scenario that might excuse or explain M's failure to make disclosure when he should have done. And the exercise that he undertook was entirely speculative, and it bears actually no relation to what actually happened, or indeed to what anybody imagined might or could or would happen. My learned friend's point is that Transocean was commenced 6 months after Halliburton, so he says M could safely have assumed that Halliburton would be concluded by a final award before M had to engage with the facts and the arguments in Transocean. And he says that that's a complete answer to my case. First, he says that this answers our complaint about non-disclosure. He says that there's nothing to disclose to Halliburton. Secondly, he says the secret communications point falls away because M would not have any secret communications with Chubb in Transocean until after Halliburton had finished. And thirdly, he says that for the same reason, there'd be no question of Chubb using Transocean as a dress rehearsal for the Halliburton arbitration. Now, the short answer is that that analysis ignores the facts. Can I just illustrate that with the facts as we know them to be in this case? All these facts and the dates in particular are in the partial award, which is at 0515, paragraph 22. First of all, the Halliburton evidentiary hearing, which is effectively the trial, took place between the 27th of January 2017 and the 6th of February 2017. So that was the trial of Halliburton. And as is very common in these arbitrations, there was then a break for the written submissions to be made. Oral closings then, in the light of those submissions, took place on the 1st and the 3rd of April. And that's very quick, actually, by arbitration standards, because one needs to find dates which can accommodate the arbitrators and the advocates, and they're all invariably very busy people. And then the final partial award in Halliburton is dated the 5th of December 2017, and that's at 0592 electronically. Now, if you bear in mind that Transocean started 6 months after Halliburton, when M accepted the Transocean nomination in December 2015, there was absolutely no reason to anticipate that there would be any preliminary issue. That is an agreed fact. My learned friend invites the court to suppose that one could be confident that Transocean would simply follow Halliburton 6 months behind. In fact, one couldn't be confident of that for a number of reasons. Just one of those reasons was that M was himself planning to retire. And in the document that my learned friend showed you yesterday, it's supplemental bundle 1, tab 1, page 198, electronic 442, I won't go to it, you will see that M asked for an assurance from the party that there was no real risk of Transocean continuing beyond mid-April 2017. Now, let's suppose that the evidentiary hearing in Transocean took place in April 2017, or even if you suppose it took place in July 2017, it doesn't matter. That would be after the Halliburton evidentiary hearing, January, February 2017, but before the award, December 2017. Now, that would give rise to every one of the concerns that we and the Court of Appeal and the commentators and the interveners have identified. First of all, on the facts of the case, the timing point was not an answer to the non-disclosure for at least 3 reasons. As my learned friend accepts, it is a fiction. M never gave his mind to the problem. So to try to reconstruct on a this is what might have been basis is rather pointless because we know what the facts are. Next, my learned friend's submissions perfectly explain why prompt disclosure is so critical. An arbitrator might think that there's unlikely to be a conflict because of his view of the timings. But it's only when somebody else whose interests are at stake, who stands back and thinks about the matter properly, that the arbitrator can then be educated as to what the particular risks are. And that actually can only be done if proper disclosure has been made. And the next point is that the facts also show why wait and see is obviously wrong. Suppose the arbitrator discovers only late in the story that the 2 evidentiary hearings are scheduled in this way. it is then too late to do anything about it, at least without causing great expense and inconvenience. In that event, he and the common party with whom he is sharing this information have every interest in not upsetting the apple cart at a late stage, with the ignorant party criticising them both for not making disclosure earlier when they should have done. Next, the risk of secret communications is an acute one. Chubb will have been through the Halliburton evidentiary hearing and the oral closings. It knows exactly what may be troubling M, because there will have been exchanges inevitably in the process. And then it has another bite of the cherry in the subsequent Transocean matter. And it takes that bite in secret. M may not appreciate that is what Chubb is doing. He may do, but he may not even think about it in that way. But it is inevitable, regardless of goodwill or bad will, that Chubb would simply tailor its evidence and submissions in Transocean in the light of what it learnt in Halliburton. And this would be bound to influence M before he's rendered his award in Halliburton, and that's the key point. And that is precisely the privileged access that we complain about. Next, the dress rehearsal is what Chubb will have had. Chubb has had the dress rehearsal in Halliburton, and it will use its knowledge and experience to improve its position in both Transocean and Halliburton, still in the future. And in my submission, this is a complete answer to my learned friend's best point. But there are other points as well that apply more generally.
Could I just ask you
yes.
a question? Do we have to inquire what a reasonable person would have done if, a reasonable informed observer would have done, if the disclosure had been made? Are we concerned with that issue at all?
I don't think so. I don't think you are. Let me think about that on my feet. But I don't think you are, because your primary concern is what does the reasonable observer think about what has happened, rather than what might theoretically have happened if something had been done.
But it might be relevant, might it, for him to hypothesise what Halliburton would have done if told?
Well, what he could have done, yes. Would you let me just think about it?
Yes, absolutely. Thank you.
There are points as well which apply more generally. When M accepted the Transocean nomination, there was no way of telling what hearings and procedures would take place in either arbitration or when. There might be any number of applications that might involve evidence and argument of all kinds. Those applications may have taken place at any time in either of the references. The order for the trial of the preliminary issue in Transocean is a very good example of the kind of unforeseen development that might affect the progress of a reference. And Halliburton was first in time, but things can change. The focus must be on the decision to expose Halliburton to risk and to confer a potential advantage to Chubb. And then could I turn next to what I call the use of hindsight, but it's a point that my learned friend dealt with actually this morning. And he was talking about the proposition that it was permissible to use hindsight to answer the question of whether there's apparent bias. And he addressed the point as if it were one of principle, but in our submission it's simply a question of relevance. The facts relevant to apparent bias in this case are the facts up to and including the time when M accepted his nomination in Transocean and failed to disclose it. That, I think, is the point made by my Lady Arden earlier this morning. The fact that Transocean was decided on a preliminary issue is not relevant to the inferences that are to be drawn from M's conduct. This is not because there is some exclusionary principle, it's just because they're not relevant. And the key point in our submission here is that there is a very important difference between what I might call prejudgment as opposed to predisposition. Whether or not a predisposition amounts to a prejudgment may often require an examination of the facts as they develop. It's entirely understandable that at point one in time there may be a kind of concern or a suspicion that maybe what you're presented with is that somebody has made up their minds too early. But then in the light of subsequent events it becomes apparent that it wasn't a prejudgment at all. It was simply a predisposition or an indication of a thought at the relevant time, but it wasn't a concluded position, and ergo it wasn't something that ultimately is something to be complained about as being an apparent bias or whatever it may be. So we do accept that an examination of later facts may shed light on earlier facts. Obviously, that is true. But what they may do is to demonstrate, one way or the other, that there was or that there was not a prejudgment. And in that sense, it's entirely appropriate to look at the whole of the later story. That is not the case here. In this case, the later fact, which is the Transocean preliminary issue, casts no doubt on the earlier facts, the acceptance of the Transocean arbitration, and the failure to disclose it. Lordships, bear with me just for a moment. I'll come back to it. Then could I turn next to the point about concurrent as opposed to spent appointments? Chubb focuses on the position where an arbitrator has in the past arbitrated a reference in which the same or similar factual or legal issues arose. And many of the cases to which my friends refer in their written case are of that kind. And they use the catch-all phrase prior or ongoing related arbitrations. They do that in their paragraph 44, core 119-0120. In our submission, that just obscures the important differences between the two situations. The most objectionable aspect of this case is that the references were taking place at the same time. That is the core problem that was identified by Mr. Justice Fraser in the Boymer judgment. I don't want to go to it in the interests of time, but the reference is Authorities 1, tab 7, page 84, electronic 958. But the point about the references being undertaken at the same time is made by Mr. Justice Fraser in paragraph 31. Now, where the related reference is in the past, the arbitrator may be able to make a better informed judgment as to the risks of accepting an appointment in the later reference. One does not have the same difficulty of the arbitrator accepting a benefit from one of the parties while sitting in judgment on the party's dispute. More importantly, one does not have the same risk of the common party communicating with the arbitrator in one reference with an eye to influencing him in the other one, because that point doesn't arise. The position with concurrent related references is constantly changing, it's dynamic. The common party can adapt its evidence and argument in response to things said and done in the other reference. The problem is not simply the arbitrator's knowledge, it is the fact that the knowledge is shared with the common party and that the knowledge can be used in real time to generate an advantage. My friends say that the arbitrator can't come to the references as a blank slate. What is required is an open mind. We respectfully agree. Once the arbitrator accepts the appointment, his or her mind is open to the parties. But ex-party communications are prohibited because they involve privileged access to the open mind. And that reminds me, incidentally, and I don't invite you to turn it up, but there's a little bit of misunderstanding here, I think, falling from something said by one of my learned friends this morning, that clause 9 in the agreement to arbitrate, the terms of appointment, says not only the parties agree that there shall be no ex-party communications between any party or any representative and any arbitrator, but it also goes on to say regarding any matter in these proceedings. And I think that those words were omitted in an observation made this morning, but they're important words. Could I turn next to say something about the Bermuda form, which the other side suggests is really rather a special case, very similar to the LMAA or the GAFTA type arbitrations. They suggest that insurance and reinsurance arbitrations, particularly in Bermuda form, are closer to LMAA and GAFTA than to the common run of international commercial arbitrations. But your lordships don't need to get into this debate. You know the attitude of the parties in this case to the problem of ex-parte communications because the parties and the arbitrators agreed expressly that there should be none. That's clause 9. Halliburton had a contractual entitlement to resist M's appointment to a related reference because that would inevitably involve an ex-parte communication in relation to Deepwater Horizon and the facts and the law relevant to the claims brought by Halliburton and Transocean under identical policies. Those are the points accepted in Boima, and my learned friends have really not answered them in my submission. The appointment of N in related arbitrations was then a matter that my friend played upon for a while, in my submission, is irrelevant. That succession of appointments was disclosed by Halliburton's lawyers at precisely the same time as they made him their nominee, or their client's nominee. Your Lordships cannot assume that Professor N would not otherwise have made the disclosure himself. The implication surely is that he would have done. And in case your Lordships may be further interested in this point more generally, we deal with it in our note on the interventions at paragraph 12, which deals with what we say about GAFTA, and paragraphs 27 to 35 in relation to the LMAA. Now, Chubb did not argue at first instance or in the Court of Appeal that insurance arbitrations should be dealt with as a special case. The Court of Appeal did not treat the Bermuda form as a special case either, and there is no evidence to support the proposition that the Bermuda form is a special case. My learned friend even suggested that it was for us to adduce evidence that Bermuda form insurance was not a special case, but in my submission that's obviously unsustainable. Now, the first error here, or the first bit of I won't use the word deception because, of course, that would be entirely improper. But the first flaw in the argument from the other side was to conflate insurance and reinsurance. For present purposes, they are completely different beasts. An insurance contract is between an insurance company and a consumer. It's a relationship which is designed to protect the position of the consumer who buys the insurance. A reinsurance contract is made between an insurer and another insurer. They're both in the same trade. I'm sure they would object to the word trade, but that's essentially what they're doing. Now, Bermuda form arbitrations are not between two members of the same trade who may sign up to particular rules and notorious practices which are appropriate to dispute resolution. The expression used by GAFTA is for the trade, by the trade, and that rather encapsulates the point. Paragraph 6 of the GAFTA submissions, Intervenors Bundle Volume 3, Tab 10, 0665. The nature of Bermuda form cover is that making a claim is a one-off for the policyholder. Pursuing a disputed claim by arbitration is even more rare for the consumer, the policyholder. Now, Chubb argues that policyholders typically instruct solicitors who are, and they say, experienced participants in London insurance arbitrations. They say that in their note on the interventions, paragraph 12C. Now, Chubb does not say that such solicitors will necessarily be experienced in Bermuda form arbitrations. If they were to say that, it would be rather contentious and not supported by any evidence. In any event, it's irrelevant. It doesn't go to the policyholder's expectations when it enters into the Bermuda form contract containing the arbitration clause. All it shows is that when the dispute arises, the policyholder seeks specialist legal advice. It does not support the proposition that policyholders have agreed to participate in arbitrations governed by any standards other than the standards that apply generally to international commercial arbitration. They are entitled to the gold standard. None of the commentators say that the Bermuda form arbitration should be dealt with in a special way or by adopting special standards. And the commentators include Mr. Stanley, one of the authors of the leading text on Bermuda form insurance, Mr. Hancock, and you know about Mr. Hancock because we've mentioned him a number of times in these proceedings. But these are very experienced gentlemen operating in this field. Guidant is itself a Bermuda form case. There is no suggestion in the judgment that the policyholder's concerns were rendered less legitimate by the context, or that the policyholder had impliedly agreed to participate in an arbitration with special rules. N, Professor N, upon whose special observations we rely, is an eminent international arbitrator on whose published views Chubb relies in a number of contexts in the paperwork they provided to your lordships. He has done a great deal of Bermuda form arbitration work. That's clear from his CV. He plainly does not think that Bermuda form arbitrations are different from the common run of international commercial arbitrations. If he did, indeed in this respect that we're concerned with here, he couldn't possibly have produced, as he did, his special observations. GAFTA arbitration is a different beast from the Bermuda form arbitration. The average dispute is likely to be in the realms of thousands of dollars, given that the total of all sums awarded in 2018 was about $31.5 million. So between a large number of arbitrations, that's likely to suggest, or does suggest, fairly low numbers. The appellant's responsive notes, tab 1032. It's not surprising that arbitration of small disputes for the trade by the trade may involve the adoption of rules and practices that are acceptable within that trade, but it can't be the default standard for non-trade international commercial arbitrations. Chubb also relies upon a report provided to GAFTA by Arias. I think there was a reference to that this morning. Now, the Arias is the Insurance and Reinsurance Arbitration Society. Its chairman is, as was explained, my learned friend Mr. Scory. Arias actually had no permission to intervene. The note is at Intervenors Bundle 2, tab 10, 0684. The note is entitled Treaty Reinsurance in London. Arias specifically disclaims any expertise in or knowledge of Bermuda form insurance. Might be worth looking at that. Can we just very quickly have a look at that? It's 0684. Well, I'll just give you the references in the interest of time. You got it? And there was a bit in 6 as well. Yeah. So it's in the end of the last couple of sentences of paragraph 2. On 0684, for the avoidance of doubt, Arias UK was not established to address the needs of Bermuda form market. The committee is aware that some members of Arias may accept Bermuda form appointments, whether for claimant insureds or for insurers, but does not concern itself with that class of US excess liability insurance. And then paragraph 6, which is on the following page, 0685, they say, in summary, it would be fair to regard reinsurance treaty arbitration as a modified form of trade arbitration, where the parties will always be members of the world's reinsurance market, with arbitrators drawn from that industry and from amongst its expert advisors. So it's really not to the point. It's got absolutely nothing to do with the case we're concerned with here. It's comparable with LMAA, and GAFTA. It is not comparable to the kind of insurance issue that we're concerned with here, or the arbitration structure that we're concerned with here. LMAA arbitration also has special characteristics. Oh, there's another reference there. There was another reference this morning to the United States case, the Lloyd's case. The reference was Bundle 4, tab 93. And the electronic is 2068. I would merely, if your lordships would be kind enough to go back to that, and forgive me if, when I say lordships, I also mean your ladyships as well. But that was, you will see, a reinsurance case. But I don't need to go back to it. LMAA has special characteristics, as I say, that distinguish it from mainstream international commercial arbitration. Mr. Gaunt of the LMAA acknowledges this in his witness statement, and we deal with that at paragraph 10 of our note on the interventions. And the appellant's responsive notes, tab 1005, and there are two key distinctions. First, the participants to LMAA references are industry participants, and they are what we call repeat players. They're ship owners, charterers, cargo interests, and they're all consulted by LMAA when it comes to determining the content of the rules of the arbitral body. They all assent to the rules and the notorious practices in London maritime arbitration. And exactly the same is true of the participants in GAFTA arbitration. Secondly, the LMAA terms make special provision to deal with related references with only one common party. And we deal with that in paras 28 to 31 of our note, which is at 010. An LMAA arbitrator in M's position would disclose the related appointment and put in place measures to protect the non-common parties. And he would be entitled to do that even without the consent of the parties to the arbitration, because he would have the power to do it. My learned friend refers to the textbook, Jacobs, that's of course Mr. Justice Jacobs, Masters and Stanley, quoted in paragraph 52 of the judgment of the Court of Appeal, core bundle tab 90190. But this is just a reference to what the authors perceive to be the current state of the law based on Lockabale and Amick. And we now know precisely what Mr. Stanley thinks the law should be on this issue because he's published his beliefs and views. We also refer to other important statements made by the authors concerning the acceptance of related appointments. I haven't got time to go to it, but your lordships I'd be very grateful if you could go to our written case, paragraph 130, core bundle, tab 5, 0092. It's okay, I won't go to it. Think so? Okay, forgive me, I'm being pressed from all fronts here, but I'm prepared to listen to Mr. Kitchener because he's a smart chap. If we could go to paragraph 130 of our written case, tab 5. Yes, I remember. So the Court of Appeal referred to para 52 as I've already indicated, and we know the current view of Mr. Stanley, that's the point I've just made, and then there are a couple of references which I do want to draw to your attention. The authors state the practical reality of selecting arbitrators in the modern world is that each party will be hoping to appoint someone whose views accord with the position adopted by that party in the arbitration, and so on. In theory, at least, any unfairness should be compensated for by a strong and independently minded chair or umpire. And then B, the court would be kind enough just to read that for yourselves. I'm going to come back to the point later on in these submissions about the chair and what one might call the wingmen, with just a small point, and I'll come back to it. So next is the suggestion made by my friends that there is a narrow pool of Bermuda form arbitrators. The sole basis on which my learned friends argue that the Bermuda form arbitrations are comparable with GAFTA and LMAA is the supposed narrow pool from which Bermuda form arbitrators are selected. But actually, there is no evidence of this, and it's completely wrong. There are no required characteristics of a Bermuda form arbitrator. The textbook by Jacobs, Masters and Stanley has a section entitled The Selection of an Arbitrator. The reference is Authorities Volume 7, tab 179, Electronic 3079. I'm not going to go to it. There's no reference to arbitrators being selected from a small pool. Still less the supposedly very limited pool referred to by Chubb in its note on the interventions at paragraph 12c. The textbook writers give an extended discussion of the different and wide pools from which Bermuda form insurers and policyholders often select. The insurer will usually select an English QC or a retired judge. The policyholder will often select a US practicing lawyer or a retired judge who, if possible, their words, will have knowledge of New York insurance law. The chair will usually be either English or from a non-US common law jurisdiction, although he or she may be from the United States. But in any event, it's difficult to understand the suggestion that M's duties of disclosure are somehow reduced by the fact that the arbitrations are on the Bermuda form. The IBA guidelines contain separate rules concerning the need to disclose multiple appointments on the one hand and appointments in related arbitrations. So there's a difference there under those rules between multiple appointments and appointments in related arbitrations. The need to disclose multiple appointments is addressed by Rule 313. The need to disclose appointments in related arbitrations is addressed by Rule 315. My learned friend relies on footnote 5 to the guidelines, which says there's no need to disclose multiple appointments in certain limited circumstances in some specialist fields of arbitration, but it doesn't mention insurance as one of those specialist fields. In any event, there is no similar exclusion from the rule concerning the need to disclose related appointments. And the reference to those rules and those paragraphs I've just identified is Authorities, Volume 2, Tab 48, 1379 is the electronic reference. Can I next say something about the authority to which your lordships or the court was referred this morning? This is the LCIA reference number 81160. This case, Chubb says, supports its argument that a special and permissive approach is required in London insurance arbitrations. Could your lordships take up, I think it's from memory, I think it's bundle 8 of the authorities? Tab 2? 210. Tab 210, it's right at the back of bundle 8. Yeah, volume 8 of the authorities. I'm grateful to my learned friend. And my learned friend drew to your attention paragraphs 4.11 to 4.14. And I'm not going to remind you of that. But unfortunately, the version, it happens in every single case actually. The version that's provided here is incomplete. And we have provided the fuller version in our thin appellant's additional authorities. And you see, the problem is that the version that was produced by my learned friends cuts off halfway through paragraph 4.20. You should have a very, very thin bundle which contains the full extract. So I want to do two things here. First of all, I want to show you 4.15, which my learned friend did not read. On the other hand, the general purport, this you remember this is the division of the LCIA giving ruling. On the other hand, the general purport of requirements as to an arbitrator's independence and impartiality, the law on which has been developing over the last decade, could not be ignored. And then if you go over the page, if you go down to 420, half of which, as I say, is cut off from the thicker bundle. So what happened, if you go to 419, you can see what was going on. And the greed of counsel, I think, is what's being discussed in that previous paragraph, and entirely understandable. The impression would have been different had the arbitrator indicated his intention to disclose, or had immediately disclosed the conflict, or had indicated his intention not to accept future retainers from parties to the arbitration pending its completion. That was completely anathema to him. But then in 420, although the latter course might not have been considered desirable by a leading barrister in the London insurance market, the division, that's the LCIA, considered that a proper balance between arbitrator independence and impartiality and the characteristic of a niche market was to be resolved through the disclosure process. And then, this of course is omitted as well, next paragraph, for all of the above reasons, the division upheld the claimant's challenge and ordered the disqualification of the arbitrator nominated by the respondents. Now, in that case, the challenge, as you can see, was to a QC selected as a party appointee by, and this is a very important point, by insurer and reinsurer respondents. So there were insurance parties to this arbitration. So it is not, this is also about the insurance side of the story. The claimant appears to have been the insured. The respondents argued that because the pool of insurance and reinsurance specialists in London is small, it was inevitable that the Silk would have acted for and would continue to act for the respondents as an advocate and would be appointed by them as arbitrator. And it was really an argument for special treatment. And I've shown you the paragraphs, and in my respectful submission, that decision supports our case, not the other side at all. Then I want to turn to a separate point, the receipt of benefits by the arbitrator. My learned friend's main answer to this seemed to be that the draftsman of the Act did not include a separate requirement of independence, though the terms of appointment in this case do. And that is a fact which is consistently ignored in the other side's argument. Independence is specifically catered for in the terms of appointment, I think it's clause 7. Our complaint is not about lack of independence in this sense. It is about apparent bias. Sir Peter Creswell could hardly have been thought of as dependent upon his Qatari appointment. He hadn't earned a penny from that appointment. The complaint was that he received a potential financial benefit from one of the parties to a case before him. In this case, the fact that the losing party in Transocean would bear the ultimate burden of paying M's fees is quite irrelevant. M still receives a benefit by reason of his nomination by Chubb, who at the end of the day ends up paying, of course will be resolved by the outcome of the arbitration itself. But he is put in a position to earn or to receive the benefit by reason of the nomination by Chubb. Can I turn then to say something I've already indicated a moment or two ago? I would say something about this, the position of chairman and party nominees. Now, everyone accepts that party nominees are in a slightly different position to the chair. M accepts that it is particularly important for parties to be able to have absolute confidence in the chair. And he makes that point, and we've dealt with it in our written case at paragraph 84, core bundle, tab 5, 0077. And in that paragraph, as you'll see, Jacobs, Masters and Stanley make a similar point in their book. My learned friend Mr. Kimmins pointed out at the outset of his submissions yesterday the interesting fact that dissents are invariably written by the appointee of the losing party. It's quite a revealing point. My Lady Black described party nominees and chairs as she put it, I think, coming from different directions. Absolutely right. Now, it is difficult for this notorious fact to be overlooked by the informed observer. There's a delicate balance in arbitration that involves each party having only one nominee. M's conduct gave rise to the impression, and I'm sorry for repeating it, but it is a fundamental point, that Chubb had two nominees. If your lordships are attracted to the LCIA's position, which is that the approach to party nominees and the chair must be the same, that must mean that the highest possible standards must be expected of both. It would be a powerful reason to require everyone in the process to meet the gold standard. And then, it's really my final point, and I want to come back to the point raised by Lady Arden. You can deal with that. Very good. Under there, sir. Now, dealing finally then with consistency with international standards. Now, you've heard from the LCIA and the ICC. You have the written submissions of the Chartered Institute. It might be important that the Chartered Institute represents the arbitral community at large rather than any individual arbitral institution or arbitral institutions in general. As the House of Lords made clear in the Law case, you remember the one about the Employment Appeal Tribunal, the expectations of the informed and fair-minded observer develop over time. Practices acceptable in the past must be judged against modern standards. Your Lordships know that modern standards are, you know what the modern standards are. You've heard it literally, and they'll forgive me for so describing them, from the horses' mouths. It's extraordinary for Mr. Landau to address you as an advocate on the basis that the LCIA and the ICC and the Chartered Institute are not giving you a reliable account. I mean, he's saying, don't accept what they say. I mean, it's not exactly a difficult judgment call to make in the face of those two opposite positions. Now, we have made a number of points about ICSID in our note on the interventions, paragraphs 15 to 20. I'm not going to go to it. It's the references N006 to 7. As we explain, this court gets no help from the ICSID cases. There isn't even a court that has jurisdiction over ICSID arbitrations. It's entirely self-regulating. It's an entirely different matter and is wholly irrelevant, with great respect, to the matters that this court is concerned with. And then I think it was yesterday that my Lord Reid asked about whether there was any evidence of parties seeking to avoid London as an arbitral seat in the light of the judgment that we've received from the Court of Appeal. Now, the only answer I can give you to that is that we know, first of all, that Covington and Burling are telling their clients, don't arbitrate in London on an ad hoc basis. So that we do know. We are also aware of anecdotal evidence of a shift to other jurisdictions. But the real difficulty in answering the question is that, of course, it takes sometimes several years for this to work its way through. So contracts are being made now. What we don't know, or we've certainly got no statistical evidence on, is what arbitration clauses, if any, people are putting into their new contracts. And in due course, as and when disputes arise, and of course we all pray for disputes to arise, but as and when those disputes do arise, so the cases will come forward. But it could take some years before we see any impact. But the possibility of an impact is the critical point. And what we should be very concerned about is to ensure that London is, and is always seen to be, the best place to arbitrate in international arbitrations. My Lords, that's all that I wanted to say by way of reply, save that, and I'm afraid I have now forgotten the point, but my learned friend, Mr. Kitchener, I'm sure could just address the point that was put to me by Lady Arden.
Can I just check while you're on your feet, Lord Grosvenor?
Lord, yeah.
One of the points you made just a few minutes ago is that in this case, M accepted a valuable benefit from one of the parties to the arbitration because he accepted their nomination in another arbitration, and that was a valuable benefit to him because that's how he earns his living. And I just want to sort of identify that point because it doesn't depend on overlap or secret communications or dress rehearsals.
By itself, absolutely.
It's a very simple point.
Absolutely.
Obviously, if, for example, a judge were to receive a financial benefit, were to accept a financial benefit from a party of litigation, that would be curtains. So it really depends on what the fair-minded observer in the world of arbitration makes of the fact that an arbitrator accepts that form of benefit from a party to an arbitration which is currently engaged.
Yes. My submission is that you can't divorce the facts that you've just been putting to me from the fact of the non-disclosure.
Mr. Kitchener.
And of course, my lord, the acceptance of the benefit is something that we would say has some resonance with the Al-Mazidi case, which deals with precisely that issue in relation to, obviously, retired judges accepting positions in different jurisdictions. The question that Lady Arden asked was, if I recall it correctly, what would be would the fair-minded and informed observer consider what Halliburton might have done had disclosure been made? And we respectfully submit that that is precisely what the fair-minded and informed observer would consider. And again, that question has resonance with Al-Mazidi, because my lady might recall that one of the points made by the Privy Council in Al-Mazidi was that if disclosure had been made by Sir Peter, he could have been educated by the various parties as to what was going on in Qatar and what the relevance was of the various individuals whose conduct Sir Peter had to consider in the context of the Cayman case. So just as in Al-Mazidi, in our case, had M given disclosure, Halliburton could have taken steps to inform him of the risks. So it could have disabused him of any misunderstanding that he might have had as to the likelihood or lack of likelihood of overlap. Halliburton could have discussed any issues that might have arisen as to how the risk of overlap might have an impact given the timing points that Mullen friend Mr. Crane raised, and we could have discussed how that could be dealt with. So it's not just a question of Halliburton having the opportunity to educate M, and it's not only the possibility of Halliburton raising a complaint with M, it's also Halliburton being able to take steps to protect its position and its right to a fair process in the arbitration. So, for example, and I think Lord Grabner may have touched on this in his opening submissions, Halliburton could have suggested, well, if we have mutual disclosure of pleadings, we might mitigate the problem, or if we can arrange for consolidation of the hearings. Now, Halliburton was deprived of that right, and we say it is a right that M would have given Halliburton if he had had proper regard for Halliburton's interests in a fair process. And that's why it's so important in this case to look at the non-disclosure in the context of the fact that was not disclosed. And we say, as you know, that what we have here is the non-disclosure of a developing relationship between the decision maker and one of the parties, under which, as Lord Reid mentioned, a relationship under which benefits pass from the party to the arbitrator, but also, and you will understand why we take this one step further, under which benefits pass in both directions. And that's why we look at the arbitrator receiving the benefit, but also because he's accepting an appointment in a related arbitration, conferring a benefit, a potential benefit, on his appointing party, and that is the benefit of privileged access. So, my lord and my ladies, it's taking the position in the round that we say the conduct with which we're presently concerned is objectionable and gives rise to concerns more serious than those in Al-Mazidi, and we know what the result was in that case. Unless there's anything further.
Thank you very much, Mr. Kitchener. Oh, yes. A matter that was raised at the beginning of a hearing yesterday was anonymity, both in terms of the court withholding the the name of some respondents and also in terms of whether any anonymity order should be made. As we explained at the time, if we were going to follow either of those courses, we would need to be persuaded that there was good reason for it. If parties want to make any submissions about that, we have a few minutes. Otherwise, if you want to put in anything in writing about that, then by all means do so.
All I think I should say is, first of all, when the matter came, I didn't appear at first instance, but when it came there, because it was an arbitration matter, it was a hearing in private.
Yeah.
And then I think that the learned judge produced two versions of the judgment. One was anonymised and one was open. In the Court of Appeal, and I'm not quite sure why this happened or on whose application, I don't think either side applied, but the Court of Appeal ordered anonymisation. And there is an order in the papers somewhere, which we'll provide you with a reference to, when they made that order. Actually, that also is also an extremely unattractive feature of the case, because along the lines of what we've been submitting, because it's all part and parcel of the, you can trust the arbitrator, he's a good chap, and what's more, we're going to keep his name in strict confidence, and we're making an order to that effect. It's all part of that. So, although we are neutral on the point, essentially, if your lordship's view was that this is an inappropriate way to go about things, we would respectfully agree with that.
Well, our starting point is there is obviously law on this matter, and there's a principle of open justice.
Yes.
And this court considered all this question in the case of Guardian Assurance,
Yes.
Reported in 2010, and there has to be some cogent reason for overriding the general principle of open justice, which might be in some cases the best interests of children. In other cases, it can be the preservation of life if you are dealing with asylum seekers, for example, who are going to be returned to somewhere where they might be persecuted. But there has to be something compelling.
I respectfully agree, and all that I would say is that whatever protection was thought to be appropriate because of the privacy associated with arbitrations is long spent.
Yes.
Is long spent, particularly in this case.
Yes.
So in those circumstances, there isn't any argument that I'm aware of that would support the extreme examples that your lordship has indicated.
Yes.
Lord Chubb, neutral.
Yeah. Thank you. Well,
Yes.
Yes.
The only thing that Mr. Kimmins has pointed out to me, and I'm grateful for, is that we are not the only parties in this case.
No, I appreciate that.
And in fact, there's N
Yes.
and there's M who have not been heard on the matter.
Yes, we appreciate that. So they can be contacted. Well, the court is very much aware of the importance of this appeal, and we're grateful for the evident care with which the submissions have been prepared on behalf of all parties. We'll now take time to consider our decision.